This writ application has been filed by 140 petitioners who were qualified in TET 2014 and participated in the 2016 recruitment process but did not get appointment. The process was held by the West Bengal Board of Primary Education, which was to be held in accordance with the recruitment rules, which came into effect. Rule 6(3) of the rules in Rule 6, Sub-Rule 3 of the said rules, the following provision has been made. In the matter of appointment, priority shall be given to those eligible candidates who possess the minimum qualification as specified by the National Council of and MHRD, and thereafter the eligible candidates with the relaxed qualifications specified by MHRD may be considered, and if candidates with relaxed qualifications are considered as teachers, such teachers under the relaxed qualification norms shall be appointed with an undertaking to acquire the minimum qualification specified in the NCTE within a period of 2 years from the date of appointment. Under the said rule, Sub-Rule 3, 8 notes are there which would be taken into consideration if required. When the petitioners filed the petition, they wanted the authorities to file a report disclosing name, numbers, rank, category, etc. of the non-trained candidates who have been recruited by the board from 2014, including the date of recruitment, and to treat the petitioners equally with the non-trained candidates, etc. During the course of hearing, the petitioners disclosed various particulars collected from the publication made by the board in its website, showing that there were serious illegalities in preparation of the panel of 2016 recruitment process when viewed in respect of untrained candidates at the time of recruitment, and while disclosing such particulars, they made it clear that all their allegations of illegalities in recruitment were in respect of untrained candidates at the time of recruitment who were given appointment against 2016 recruitment process. And at the same time, it was made clear that they do not have any grievance with respect to the trained candidates who were trained at the time of recruitment and were given appointment in the 2016 recruitment process. Therefore, the candidates who were trained at the time of recruitment are outside the scope of this matter. The petitioner prayed for filing supplementary affidavit, which was granted, and from the supplementary affidavit to the writ application, it became evident that all the petitioners had qualified TET 14 and participated in the 2016 recruitment process, and they were called for interview, but they did not get the job. The aptitude test calling, which was recorded in the first order, is missing. Now, the honorable judge records that only interview. This court directed. Now, the court is inviting or calling for evidences. This court directed the board to file one report as to the petitioner's breakup of the total score sheet of 2014, TET 2014, along with the breakup score of the last impanel candidate in their respective medium category and district who participated in the recruitment process of 2016. From the breakup, the petitioners found that the alleged that the particulars given therein are absolutely false, as because the lowest number of impanel candidates was shown in the report as 14.191, whereas throughout West Bengal, 824 candidates who scored below 13 were appointed, and the petitioners prepared a tabular sheet to that effect and enclosed it as Annexure B to their exception to the report filed by the board dated 11/1/23. Such exception was filed in the form of an affidavit affirmed on 24 January 23. It was also stated in the exception that list of the last impanel candidate of different categories, namely General, SC, ST, OBC A, OBC B, was not given. I have found that there was no reply of the board in respect of the allegations as aforesaid in the affidavit in opposition filed dealing all the pleadings of the petitioners. From the pleadings of the petitioners, it is found that they wanted the marks of the last impanel candidate of different categories like SC, ST, OBC, etc., but no such particulars were supplied and produced by the board despite direction given by this court. In the affidavit in opposition of the board maintained silence in this regard. This is nothing but suppression of facts from the petitioners as well as from the court. In respect of holding of aptitude tests, the chairman of the board in his report said that the aptitude tests were taken, but from the evidence adduced by the interviewers and the candidate, it has been proved before this court that no aptitude test was taken. We are pausing here for a moment, Pilot. All relevant records were before this court, which is part of the paper book, to show that in every district, Pilot, aptitude test was taken. But with respect, the honorable judge do not refer to any of them. The honorable judge confines this adjudication to whatever was elicited under section 165. Pleadings and evidence on record, in my very respectful submission, has been ignored. In this regard, the order passed by this court in this matter on 6/2/2023, not challenged till now, is required to be quoted. That order is quoted, where I placed that order with the...
No, Mr. Dotto, where they called for the aptitude test.
Yes. We have all records annexed. I'll not go elsewhere. So, this paper book itself.
The evidence which was extracted as you are submitting, that is relating to the issue whether aptitude test was held or not.
The issue which the honorable judge considers at the time of final adjudication is only confined to whether or not aptitude test was taken.
Yes.
Although, my lord, no pleading was there. That's why, my lord, I have taken your lordship through the writ petition. Then, my lord, if your lordships may kindly skip over the table
Sorry.
at page 617 after the table. No question was asked by the appealing parties to the above interviewers. The evidence kept on record. It is to be remembered. This is the quotation of that order. I skip over those. Now, please take paragraph 10. Then page 618, para 10. Therefore, the marks given to the candidates against aptitude test is wholly illegal and false exercise to hoodwink all concerned, including the court. Paragraph 10.
Yes.
But so long, my lord, the finding was that no aptitude test was taken. The interviewers have made contradictory statements in course of their deposition. Now, kindly see paragraph 10. Therefore, the marks given to the candidates against aptitude test is wholly illegal.
Maybe the judge thought that the aptitude test which had been held is not in terms and in consonance with the
Well,
rules.
let us see, my lord, whether that has been held or not.
This issue as whether aptitude held or not, this I think will go because subject to what you say. Because maybe Lordship was proceeding on the basis that test which was held was a sham test.
Right.
That is, I think, the
Yeah,
ultimate.
My lord, there cannot be, my lord, two
Versions.
versions. Either the aptitude test was taken. If taken, it is faulty or correct. That can be one situation. The other situation was no aptitude test taken.
Okay.
So long, my lord, we had a understanding from the judgment that
there was no
aptitude test. Therefore, the marks given to the candidates against the aptitude test is wholly illegal and false exercise to hoodwink all concerned, including the court. The board has not given any reply in respect of awarding 9.5 out of 10 marks to a large number of candidates, which is absurd and an impossibility, especially to those whose academic score and TET score were very low. The table given below substantiates the allegation apart from 121 pages booklet, spiral binding, which is on record. Spiral binding cannot be a pleading or an evidence.
So who made the spiral binding?
The petitioners. Writ petition.
Record with us.
Yes, that we have put in the paper book. It's in the paper book.
Yes.
In support of their allegations as to corruption in awarding marks in the interview, the petitioners have filed a booklet of 121 pages on the basis of which it has been alleged that the candidate whose marks were very poor in secondary, in higher secondary and in TET has been given 9.5 out and 10 marks, that is full marks out of full marks 10, that is the perfect 10 in the interview and aptitude test. No aptitude test was taken at all, and the allegation that there was no aptitude test which has been proved before me. Who has proved this? The proof has to be preceded by an allegation, an assertion, a pleading.
Yes.
But how it has been proved, I'll come to that later on. But before coming to the conclusion that it has been proved,
yes,
one must come up with an allegation. Proved before me from evidences of the candidates and from the interviewers which are kept on record. Here, to elicit the truth, I had to exercise my power under section 165. For example, some particulars have been given in the said 121 pages booklet, which has been prepared from the particulars published in the web portal of the board. By the board, some candidates' marks were reproduced herein below, which shows that the marks awarded to such candidates whose results are very poor in secondary and in high secondary examination and also in TET are wholly absurd. Assessment in interview, and unless some extraneous factors, which includes corruption, as has been alleged by the petitioners and now has come to light from the investigation by CBI and ED, such absurd marking could not have been made by the interview boards in different districts. While looking into the following particulars, it has been noted by me that in the academic assessment and TET, 1, the maximum marks that could be given against secondary examination score of a candidate was 5. The maximum marks that could be given to a candidate against high secondary examination score of a candidate was 10. The maximum marks that could be given to a candidate against TET was 5. Therefore, the maximum marks that a candidate can get against the above three heads is 5 plus 10 plus 5 is equal to 20. Now I give example of a candidate before giving a table prepared from the document or record, that is the 121 page booklet. This candidate has got 2.866 in TET out of 5, 1.462 in secondary out of 5, and 3.050 in higher secondary out of 10, totaling to 7.378. But was awarded 9.5 marks in interview and aptitude test. Aptitude test was not taken out of 10, whose total score came to 16 points so and so, and thus he became eligible for appointment as a primary school teacher. Huge number of such absurd awarding of marks has come to light through the said booklet prepared from the particulars published by the board. Miller examples given. For example, Putul Bormon Singho, total marks in the academic qualification is 7 point something, and the interview marks is 5.0. Similarly, Monimala, etc., etc. This is the honorable judge records. Then kindly, after the table, para 15. The board has not given any reply in respect of the allegations of the petitioners in the pleadings as to non-empanelment of the reserved category in the panel for general category candidates of those reserved categories who got better marks than the general category candidates in the open competition. Thus, the board has violated the law declared by the Supreme Court and has committed extreme illegality. Though the relevant Rule 7 of the recruitment rules of 2016 mandates constitution of the selection committee, no selection committee was constituted for the purpose of selection of eligible candidates and preparation of panel of such candidates for appointment of teachers. It was done by one outside agency, a third party, which was not at all a part of the board, and this third party was named as confidential section of the board. This is clear violation of the recruitment rules. The board has maintained complete silence. From the gross illegality in the selection procedure in recruitment exercise of 2016 conducted by the board, it is clear that the board and its officials, including the former president who is now in custody, so and so, conducted the whole affair like affair of a local club, and now it is gradually coming to light by investigation of Enforcement Directorate that jobs of primary school teachers were actually sold to some candidates who made money to who had the money to purchase the employment. A corruption of this magnitude was never known in the state of West Bengal. A former education minister, the former president of the board, and a number of middlemen through whom the jobs were sold like a commodity are now behind the bars, and the CBI-ED investigation is being continued now in full swing. But with respect, paragraph 17 has got nothing to do with the merits of the matter.
It's a scam, Mr. Dotto.
That scam, what they say, scam, please see whether at all there was anything in the petition.
No, right. You have told us that there was
nothing was there. Simply using this catch expression, scam, corruption, doesn't mean that a case is proved. A case has to be proved even if it is scam.
So there will be no perception of the judge.
In that case, the judge should first release the matter.
First?
Release the matter with respect.
Perception in the sense from the record.
No, these are not on record. These are the personal views of the judge. But how could the Honorable Court get the name of that third agency?
If it is ultimately shown by them that they are
whether it is shown by them, right?
These are all factors inextricably bound. You cannot segregate without.
No, these were not placed before the court. I'll come to all the pleadings one by one. It has to be there in the pleadings.
The pleadings you have shown.
Nothing is in the pleading. I'll come to the other pleadings. I've just taken your lordship through the writ petition. Other things where and the sequence of pleading is also very important. When did the court invite which pleading? That is also very important. Where I have a short list of dates for that also.
So that we will hear. We are just interacting with you.
Right.
We are asking you when there is such a heart-throbbing issue of scam, which you say that it has to be different definitions can be given. But it is a fact that there had been a scam in respect of several education.
But that will not vitiate the other selection process. One selection process said to be bad doesn't mean the
can be argued against you that in order to divert from that issue, you are taking up the very basics as to whether there were any pleadings. Maybe this may be an argument on their side.
Yes, definitely. But I will deal with those also.
Yes.
But otherwise, the whole the writ jurisprudence has to be rewritten.
Yes.
Where your lordships have in a number of judgments held that whatever is there in the pleading as well as in the evidence, the court will only look into that.
7 except in extraordinary cases.
Yes. That extraordinary case has to be made out by the parties, not by the court. Court is not going to make out a case for one of the parties.
Yes. Yes, page.
Yes, ma'am. But I was placing paragraph 17.
Yes, 17. You have finished 17.
Yes. Now kindly take paragraph 18.
Yes.
Now kindly see how we are being dealt. 17 I have not started. From the gross illegality in the selection procedure in the recruitment exercise of 2016 conducted by the board, it is clear that the board and its official so and so naita pora hoye gache. Now please take paragraph 18. This is very important for me. Kindly see how my arguments are being dealt with. It is a matter to be noted that the board in its affidavit in opposition while dealing with the pleadings of the petitioners, instead of addressing the allegation of corruption and illegalities in the recruitment process, raised some niceties of law and some principles of law, but however nice or however laudable those principles may be, this court as a court of justice will fail to deliver justice, knowing fully well that sense of justice is much above the sense of law. If the writ application is thrown out on such niceties of law, as this will mean that in the name of preserving the law, the corruption would be protected, with which a constitutional court can never do, keeping in mind the soul of our constitution and the constitutional conscience. I say that in this recruitment scam, stinking rats are being smelled. So whatever rubbish I have said, that has to be dealt with by the court. Kindly see the next sentence. Even more alarming, the board placed some judgment before me in support of the niceties of the legal principles, which I do not find have any applicability in the face of the magnitude of the stinking corruption in the recruitment exercise of 2016 conducted by the board. These judgments are not required to be mentioned at all. But this is how, my lord, the advocate is being dealt. Say that these judgments are not applicable because of so and so reason.
At all in the facts of this.
No, he has not. I have referred to at least 20 judgments, not even recorded. That is why, my lord, with respect, my lord, the honorable court, my lord, bypasses the application of the principles by saying that these are niceties of law. As if, my lord, in writ court, niceties of law is not to be argued. It is a Bhakcha's court. Kindly see. Now, kindly see the expressions thereafter. Those judgments are not required to be mentioned at all in the factual situation of the case, as those are bright stars of the space, much above the ground realities, in which the unemployed youths live with tears in their eyes, because this recruitment scam is a crime against the society and also a fraud, where the board and its former chairman was well aware of the rules of the recruitment but cared a fig and started a play to hoodwink all concerned. I will only say that fraud unravels everything. Who has unraveled the fraud? Kindly, my lord, recollect.
Yes. Yes. So there are total 44 appeals in this. We were told. Now those are arising out of the same judgment. Now how many petitioners were there in all these matters? Total number of petitioners, how many?
May I say this, Milord?
How many challenged the selection process?
140.
Only 140.
Only 140.
More than 140.
No.
140 read petitions. Now any other person came into the zone?
No, not in the appeal, before the writ court.
No, before the writ court we are asking. 140. All the 44 appeals, let us clear out the facts. All the 44 appeals are arising out of the same judgment. And all the appeals are dealing with the case of 140 writ petitioners. There were no other persons. Whatever application for addition has been filed is by the teachers who are already in service. Right?
Not only that, my lord, who are in the same footing of the petitioner, that application is also filed because their petition is also pending, and the board submission is that, my lord, due to this pendency of this matter, they are unable to address the court. So that's why the additional party and one of the additional party.
Additional party. One.
My lord, can two already.
Yes.
In the first order, it is mentioned, my lord, can two is already allowed.
Who are the unsuccessful persons? So do you have that chart? How many persons in total are there? Anyway, please ascertain that. Yes. Yes, Mr. Dotto. No breather. Continue.
And there are several petition pending.
Yes, we are on paragraph 20.
Yes. But I'll just finish this judgment, Milord.
Yes.
Para 20.
Yes.
Yes. Then where paragraph 20, the affidavit in opposition of the board was filed when all pleadings of the petitioners, including the particulars placed in the court, were served and kept on record, and the board did not deal with those allegations and those material facts and necessary particulars. In such circumstances, I allow the writ petition. The appointment of all 36,000 who were untrained at the time of recruitment in 2016 recruitment process conducted by the board in the post of recruitment primary teachers were cancelled for various reasons as elaborated above. The board shall immediately arrange for a recruitment exercise. Rest is Miller how to implement the order.
So this fresh recruitment exercise which the single judge directed would be restricted to the self-same persons.
Yes.
Yes.
So my first is Miller.
Then
But the other is Miller how Miller the judgment is to be
they
worked
will-
out. Yes.
such they will be acting as para
Yes.
teachers.
That may not be Miller
Yes.
essential for the present. Therefore, Miller, this is how Miller the litigation proceeded. One facet I have demonstrated before the court. The other is Miller as to when Miller the pleadings were called and what had happened in between. I'll place those also. Then Miller. Oh. But maybe come back after the vacation. Maybe.
Why vacation, sir? You can finish your argument at least, because your argument, your judgments we will take into account.
Wait.
Tell me. I will want to- How long will you take, Mr. Dotto?
Miller, at least one half. Another one half.
1 hour.
One half. Half of a day. Well, I have to show a lot of judgment. First is Miller, my judgments which I placed. Whatever judgments I have placed Miller has not been noted even.
Oh. On factual aspect, do you want to take us to any other document?
Yes, there are some other documents which I need to take care of. But these findings Miller are not based on anything.
Follow Kartik. First May.
আজকে কত আজকে কত রে আজকে হচ্ছে 7 So I'm minded to hear it this side of the vacation Miller in that case. Okay, bhai. Okay. জজ সাহেবের সাথে কথা বলছি তোরা তো কথা বলছি আমি যদি বলি ছুটি পর করবো জজ সাহেব না বলি
Yes.
Miller, in that case Miller kindly keep it Miller in
It
the
is not we are minded, it is our work. We have to finish it.
yes.
It is our work. We would only request the councils to
Miller,
at
kindly
least you
keep
can
it Miller.
shorten the time because it is awaiting decision for a substantial
Right.
period. That is a request to the councils. Now it is up to you people to come and tell us.
Miller, kindly keep it Miller in the week of 19th starting from 19th.
Then
When-
on that day you are finishing your arguments, and it would
But
have
I
been
hope
very
so Miller. But I hope
helpful to us had we got the list of judgments which you are placing.
but that Miller I can supply to the court. Not today but in between I can supply. That I can give. Ah, 19th.
Yes, please, okay. And if on 20th 2 p.m. you cannot finish, if possible, we will keep it as a continuing matter so that you can finish your argument. Prior to the vacation, at least you can finish your argument. So that now it is their turn.
We have to make submissions, man.
Yeah.
We have to make submissions. We are the successful candidates.
You are added applicant, sir. Which appeal you have? Achha, please let us know.
May I explain, Milord? May I explain, Milord? I part two. One second.
So
There are 44 appeals.
Hmm.
One appeal is by the board.
Hmm.
The other 43 appeals are by the successful candidates who have lost their job.
Right.
Or in other words, the 36,000 who have lost the job, many of them have preferred the rest 43 appeals. There are, Milord, certain.
It was granted to them.
Yes. And the applications which your lordships are facing, the addition.
The successful candidates.
No, they are the unsuccessful candidates.
Oh,
Standing on the same footing with the writ petitioners.
Or the rate petition.
Fence sitters will deal
I am
with.
the candidate.
There are also successful candidates who have not been impleaded. They have also filed an application for leave to appeal.
Other appearance to decide among themselves, go to the lead counsel evidence.
That way, I think, Milord, this matter cannot be decided.
at least
Everyone
there
has
should
right
be
of
there should be a subject to what you say. The arguments can be urged before us by any particular advocate. If any further addition required, let that advocate continue. So I don't know. Pardon?
But we will not repeat, but we may be given an opportunity to address it.
So you are the appellants, we will hear it. There is no problem with that.
The last petition, my lord, also the same. Don't repeat. If you want to say something new, you are always welcome.
No, not new. You will certainly place your case. We are just requesting you, at least if one council can urge so that time can be shortened. No?
No repetition.
Yes,
So, Mr.
Okay, what is the-
No, you decide that who will be the council.
Start after the vote. Particular applicants, candidates.
So you sit together, sir. You don't expect the court to keep in abeyance for the entirety future. Don't insist unjustly. We have stated very simple sentence we have asked. We have said if there are 10 councils, you decide that who is going to say something. Maximum 2 persons we will give. This way it cannot indefinitely continue. We will not allow that. This is we are. So you decide. We are not either Mr. Mitra or whoever is there. No, Mr. Devbarman, this way we cannot, because then what happened? Had Mr. Dotto adjourned till such and such. This we will do it for innumerable times to come. This court will not do. You wanting after vacation, we wanted that the original appellants will complete their arguments. That is Mr. Dotto and the other applicants who are similarly situated with them.
What happened, my lord?
Let us finish. So we will hear you, sir. We are wanting to curtail the time. So that is, we would again request you that let one council address us. Let one council or 2 council maximum. No, 3 or 4. PP cannot. So you tell us when will you argue? You tell us the date that we will argue on that. 20th, Mr. Dotto is finishing. Very good. Then you are continuing. So that we can finish off the persons.
Yes, Milord, before the vacation, if your lordship, Milord, if your lordship permits. Yes, Milord, that will be the best. We can conclude it.
No, what we are just interacting with you. We cannot do on our own unless you assist. So we would be requesting the councils. We are fixing on 20th. Now, if suppose the person who will be arguing, he can continue till the next date. We can close the argument so far as the appellants are going. Please have something for us. There are 44 paper books we are put. So this is understood. So this is understood. We are keeping it on 20th. If Mr. Dotto will finish, and prior to the vacation, we will give you some occasion. You finish your arguments.
Yes.
You will get a chance to reply also. Let them start again. Mr. Dotto appearing for the appellants in the appeal.